All right, get to show cause hearings. So you have served your summons and complaint. Tenant has filed a notice of appearance, and there's a recent case, and I'm sorry I don't have the site at my fingertips. Basically, a notice of appearance for the purposes of eviction actions constitutes, um, well, I don't want to say constitutes an answer, but it triggers the requirement of an order to show cause. So if you get a notice of appearance from a defendant, don't think you're going to be able to go forward and file a motion for default on them. Okay, that's statewide. You've got to bring them in a show cause. We'll get to this a little bit later on, but in the city of Tacoma, you're required under the code to bring them in on show cause. So you cannot default a tenant in Tacoma, even if they don't file a notice of appearance. All right. I thought I saw a question flash. Is there a question out there?
I did see someone raise their hands, but I think that they lowered them. So if you
Okay.
had raised your hand,
Ask.
please ask the question.
All right. We good? All right.
It appears to be.
Okay. Onward we go. All right. So standard for show cause hearings. They're statutory set 59-18-380, 59-18-390. All right. This is a summary proceeding to determine the question of possession. That's all we're talking about here is possession. We're not talking about the rent. We're not talking about how the place was destroyed. Nothing like that. Just who gets possession of the premises. Um, So at the show cause hearing, the court will determine if the landlord is entitled to a writ of restitution before a trial on the complaint and answering. Okay, and so landlord's burden of proof. Okay, remember we talked about statutory procedural requirements. Was proper notice served? Was a proper summons and complaint served? Okay, summons have the proper information, proper return date. The summons requires you to have information on there regarding the contact information for the landlord and or the landlord's attorney. That includes if you have a fax number, you have to have a fax number. There's a case out there where an eviction action was done and the landlord's attorney did not put his fax number on the summons, although it was statutorily required. And because of that, the case was dismissed. Are breaches in the eviction notice proven? All right. So again, it comes back to the notice. You need to, again, payment of rent, that's one issue. You've got to have those payments broken out by month, each month broken out separately. Utilities broken out separately by month. The month-to-month periodic charges broken out by month. Don't lump them together. Okay, break them out and then they're total. Um, if there are breaches regarding any rules or regulations, again, date, time, occurrences, specific details, have those been included? All right, and lastly, is the tenant still in possession? Right? Because if you get there and you're and the landlord cannot testify that the landlord or that the tenant is still in possession. Remember, we talked about the very front of this thing. If the tenant is not there, the court does not have a jurisdiction to proceed in issuing a writ of restitution and going for a show cause action. So it is highly advisable if you're an attorney to let your client know that they've got to do an occupancy check 48 hours before the show cause hearing. So they're going to be able to testify under oath to the judge that, yeah, the tenant is still there. Well, if they're not coming to the door, how do you know they're still there? Well, is their car in the parking lot? Have they emailed you with a complaint in the last 48 hours? And now 48 hours is what we use. I think if you're within the last week, you're going to be okay. But 48 hours is going to be better, right? So you're going to need that type of testimony. So if the landlord is able to establish by preponderance of the evidence that there's been a breach, the court will issue the writ of restitution. And the court is obligated to do that on the landlord if the landlord meets their burden. But it is kind of incumbent on the judge or the commissioner to do a somewhat substantial investigation. So landlords are a little bit at a disadvantage because the tenant, under statute, can respond orally at the hearing, or in writing ahead of time. And so it may be that you're hearing these oral defenses for the first time at the show cause hearing. And if your notices aren't complete and the tenant is kind of arguing around some of the instances, um, uh, you're going to be in trouble. That's why we want those notices to be loaded with specific facts so you can refute based upon the notices any representations that might be orally being made at the time of the show cause hearing. All right. And so basically, again, the court is going to determine whether or not there's any potentially viable legal or equitable defenses on behalf of the tenant. And if they are, then you will be set for trial. So, and again, we're talking about potentially viable defenses. Um, a lot of times you'll see the judge or commissioner pro tems actually like to do this a lot in Pierce County, where they'll examine the parties and witnesses pretty much in depth and to try to build away the facts against the law and determine whether or not they can go forward and issue that writ of restitution. So, and again, if the landlord does not carry their burden, then you're going to be off to trial if your case has not been dismissed. Expedited trial statutory within 30 days. In an application that's not happening these days, courts are pretty well backlogged. Pierce County is actually pretty good. Other jurisdictions, not so much. They'll get to you pretty quick, but probably not within the 30 days. All right. And again, similar to a summary judgment, your show cause hearing is going to be based upon whether or not there's a genuine issue of material fact pertaining to the defense. And if there is, case law holds that it has to go to trial. Okay, so that's basically as far as the burden of proof regarding the show cause hearings. Typically, show cause hearings are for the most part, especially when it comes to non-payment, the amount of evidence put on is pretty straightforward, pretty well scripted. You're going to, from the landlord's perspective, you're going to have your client identify themselves, identify their relationship to the plaintiff, it's the corporate plaintiff, confirm that they are familiar with the defendant's tenancy, cite the terms of the lease as far as how much the monthly rent is, confirm that they served a pair vacate notice, whatever notice they did serve, presuming it's pair vacate notice, the date that it was served, and that the tenant did not pair vacate within the statutory time period, that they have an accepted rent subsequent to the source of that notice, and then that the tenant is still in occupancy. And that, for the most part, is going to be the lead examination from the landlord's part, and then from there on, you're going to be dealing with the any type of tenant rebuttal evidence. Okay, so let's say you got personal service because you're going to need it, and now we're talking about judgments, right? So you can take a judgment at the show cause hearing for the back rent amounts due and owing. In Pierce County, the verbal testimony of the landlord's rep is typically going to be enough to substantiate it. In my cases, we actually submit ledgers, but certainly not required. With regard to attorney fees, there are limitations. So under 5912-290 sub 3, if the amount of rent that has been awarded is equal to or less than 2 months worth of rent, you don't get your attorney fees. You still get your costs, but you don't get your attorney fees. Or if the tenant failed to file a responsive, failed to respond to a pleading. So what does that mean? So if there's no response at all, then you are not going to get your attorney fees. Okay. This case that came out where the court basically held that when a tenant had filed a notice of appearance, that the landlord is not obligated to bring them in on show cause. I have seen that be used as a basis for getting attorney fees. So basically, the tenant files a notice of appearance. Um, that's considered responding to a pleading, even though they haven't filed a full-blown answer. At show cause, the attorney may still get their fee award based upon that NOA, even though it's not a full-blown answer, even though the tenant did not appear at the show cause hearing. Okay, and then again, we talked about alternate service. If you've done that, you're not going to get any fees or costs because of the alternate service. You're just going to get your order for the writ of restitution. Let's see. So when we talk about the tenant seeking any type of affirmative relief, okay, this becomes an issue as to whether or not, if he's filed by alternate service, what can happen to then trigger personal jurisdiction over the defendant to allow you to get your attorney fees, right? So you've served by posting a mailing, but now the defendant appears. The fact that they've appeared, does that in and of itself mean that you get your fees? And under Negash v. Sawyer, that is not necessarily the case. Okay, so they need to do something more than just appear. There needs to be some type of affirmative response to the allegations in the complaint.